Hey everyone, well thanks for joining. We'll wait a couple of minutes to see if anyone else is joining, but whilst we're doing that, we'll do some quick intros. My name's Lachlan, I'm the CEO here at LegalVision Australia and LegalVision New Zealand. And I've got George Toomey with me, who leads up our New Zealand practice. George, you want to quickly introduce yourself whilst we're waiting for a couple more attendees?
Yeah, thanks, Lachlan. Yes, I'm George, and I am heading up our corporate commercial practice in Australia and New Zealand. And so we launched in New Zealand at the start of this year, and have got some good experience in terms of Australian companies trying to launch into different jurisdictions, mostly New Zealand. So hopefully a lot of attendees on this webinar will get some benefit from those experiences that we've had as a law firm, as well as the SaaS businesses that we work with in Australia in terms of their launches into New Zealand as well.
Yeah. So look, the purpose of this presentation is really to take you through the basics of expanding your business to New Zealand. Now, a lot of Australian businesses will consider New Zealand as, as maybe the first sort of international, expansion opportunity when they're growing. And there's obviously lots of reasons for that. Culturally, the countries are very, very similar. It's, probably the most similar to countries that you could find. It's a close market. The time zone issue is not a big issue. And it's a small market that a lot of businesses will go, right, we'll test out our international expansion into New Zealand. And because it's a small market, we don't have to, spend huge amounts to expand there. So, look, it makes sense for a lot of Australian businesses, and look, vice versa as well. We have a lot of New Zealand clients who obviously expand to Australia as their first international port of expansion. So what we wanted to do was quickly run you through some of the basics, just the basic things you need to consider when expanding to New Zealand. And George and I will take you through that. Then what we'll do is have room for questions. We've already received some questions, actually pre-webinar. So, we'll answer some questions and then kind of at the end, explain how LegalVision is well positioned to assist any business that's looking to expand into New Zealand. Got a quick agenda, contents that we're going to go through there. I won't read through those. But basically, we can send the slides around afterwards. These kind of 5 points are really the main key questions you need to ask yourself. So let's move on to the first kind of section, which really revolves around the company's office incorporation process. So, George, do you want to give us a bit of background on what the company's office in New Zealand is and how it all works?
Yeah, sure. So this is probably, I guess, the most straightforward part of the launch is actually incorporating your company in New Zealand. So the company's office website is where you go to do that. It's a really straightforward website, really self-explanatory. At kind of a high level, in terms of what that process looks like, the first thing would be to do is set up what's called a Real Me account. And that basically can access a whole lot of different government services through that one login. So it's worth doing. So there's things like company's office website, your IRD, IPONs if you're registering trademarks, along with sort of local council services as well. So once you've got that set up, then it's a matter of just reserving your company name and then submitting all the information onto the company's office website. So really basic stuff. So, who are your shareholders and directors? What's the initial share capital going to be on incorporation? What's your basic company information? So addresses, contact details, and the like. Once all that information's in there, then the company's office website will basically spit out your director and shareholder consents. So that's basically, I consent to act in that capacity for this company from incorporation. Once those are signed and submitted back onto the company's office website, you can expect to get confirmation of incorporation probably within 1 or 2 hours, provided it's during business hours in New Zealand. And that confirmation will be your certificate of incorporation, and then also a company extract, which is basically a drawdown of all the information that will be publicly available going forward. So it's a pretty DIY process. and often people will just do that themselves. There is value in talking to, you know, your lawyer or your accountant before that, so that we can kind of help you guide you through sort of the bigger picture questions. So, you know, what does your share capital look like from the outset? You know, are you going to raise capital in the next 6 to 12 months? So maybe it makes sense to set up with more shares than just sort of 10 or 100 token shares. And equally, you know, how are you going to have your shareholdings? Are you going to set up a dual company structure, which might make sense if, you know, you've got key assets that you want to protect out of your trading liabilities. Equally, your founders might want to set up a discretionary trust to hold their shares. So there's all sorts of, you know, different considerations that we can kind of help lead you through, so that you're not reversing what you've done right at the start, and just setting yourself up for the future going forward.
I think like the key message as well is, you know, for anyone who's running an Australian business and who's set up an Australian business, it's pretty similar. You know, we have ASIC in Australia. It's a little more complex in Australia in terms of it's a bit difficult to use the ASIC website to incorporate a company. So a lot of people in Australia will use, you know, a different type of website to incorporate a company, or they'll go to a lawyer to do it, or an accountant. But ultimately, you know, it's all pretty similar. And that's, again, one of the benefits, I think, of launching in New Zealand. The legal framework is not that different, which is good. All right, let's talk quickly about the kind of corporate governance documents that you know, that you would generally have for a company, and if you're launching in New Zealand, it's similar. So particularly the sort of constitution, shareholders agreement, and the like. Can you give us some insight into how that all works in New Zealand?
Yeah, sure. So those are the two documents that we're looking at when we talk about corporate governance in New Zealand. They're not compulsory, neither of them are compulsory. So when you look, you know, firstly at the constitution, that's the document that basically, you know, sets out all your rights, your powers, your duties of the company, the board, each director, each shareholder. If you don't have a constitution, then you'll be governed by the Companies Act, so that's your default position. But if you are, then, or sorry, if you do adopt a constitution, then, you know, the Companies Act still applies, but there are certain provisions in that you can either, you know, modify or essentially, you know, opt out of. And so we often will be advising, well, we always advise our clients to adopt a constitution just to take advantage of those flexibilities to help you going forward. And the key things there that we sort of hone in on in terms of why we would adopt a constitution is, the first one that comes to mind would be your preemptive rights on transfer. So there are no preemptive rights on a transfer of shares under the Companies Act, so you have to build that into your constitution.
Do you want to just explain to those of us who aren't lawyers what preemptive rights means?
Yeah. So that's basically the idea is if you've got a share, it's important to start up companies because if you've got shareholders that want to sell their shares, usually you're talking about quite a closely held company with shareholders that are adding value in a certain way to the growth of your business. And so a preemptive right means that if you've got one of those shareholders that sells their shares, wants to sell their shares and get out, they have to first offer them to the existing shareholders before they go out to a unrelated third party. So it means that, say as a founder, you don't get one founder selling and then suddenly you've got another shareholder which has got 30% of the shares that's adding no value to your business. So it's a really important thing to build into your constitution if that is an important factor. The kind of reverse of that is your preemptive rights on a share issue. So the same again applies where if you're issuing new shares, you first offer them to your existing shareholders so that their percentage shareholding stay the same. So they are built in as a default position in the Companies Act. So you do have to offer them to existing shareholders, but you can contract out of that in your constitution. And again, your high growth startups really like that as an option because it allows you to raise capital really quickly without having to go through that process of offering to existing shareholders first.
Okay. So the only thing worth mentioning, I think, on this as well is if you're an Australian business, presumably you have an Australian holding company, and when you're expanding internationally, that international business or that international company, so for instance, in this case, a New Zealand company, that's going to be owned 100% by the Australian holding company, right? So these issues around preemptive rights and the like are probably not necessarily going to be relevant to to a lot of businesses that are expanding into New Zealand. So in those circumstances, would you still recommend a a constitution, or how does that work?
You can absolutely get away without having one, but typically you still would. So you'd have a constitution that's basically set up on the basis that we are a wholly owned subsidiary. And so the reason you might want to do that is that if you do that and it's a wholly owned subsidiary, then you can actually act and you can have your directors acting in the best interests of the holding company rather than in the best interest of the company itself. So that's a really important thing that wouldn't apply otherwise if you didn't have the constitution. So there is a sort of, they are pretty generic documents, but you'd put in place one that is specific for someone who has got a wholly owned shareholder, that is wholly owned by an Australian company.
Good. And again, look, worth probably mentioning, it's not a massive, piece of legal work to get a constitution. They're pretty kind of standard documents, and something that we can do for you pretty quickly. So bear that in mind. It's not a big cost. All right, what about shareholders agreement? I think we've talked about some of the ins and outs there, but is it necessary?
Yeah, so those ones depends on the circumstances. So that's your basically an agreement between each of your shareholders and the company as to how you're going to run the business going forward. So it's more of a bespoke document than your constitution. Basically sets out guidance around how you're going to deal with certain situations. So what happens if a shareholder dies? What happens if one wants out? What decisions are appropriate to be made by the board itself, or which ones need to go to special shareholder resolution because it might be a critical business decision. So it sets out all of those things. So you can quickly see that while you don't have to have one, it's really useful, particularly if something goes wrong. We have had sort of overly enthusiastic clients in the past that have got a sole shareholder that wants to put a constitution in place. a shareholders agreement in place. In that scenario, not necessary for obvious reasons because you've only got one shareholder. But if, for example, you've got an ESOP allocation and some of those options are due to vest soon and those employees can exercise them, so you're looking at getting other shareholders in the company, or you're getting external investors in, those are the points in time that we say, look, it's really critical now to get that shareholders agreement in place. And obviously, if you're in a wholly owned subsidiary of an Australian company, it's not going to be necessary from the outset. But equally, we do get some people that decide to launch in New Zealand or other jurisdictions, setting up, a separate company with equivalent shareholdings. And so the reason they might want to do that is if they're raising capital, they want it just to be in respect of that particular jurisdiction, in which case, again, as soon as you're getting more than one shareholder, then you need to be thinking about, well, actually, now's the time to put in place a shareholders agreement. What does that look like?
For sure. Okay, good. Let's move on to some of the practicalities around, being an Australian business that's effectively setting up a New Zealand subsidiary. Are there, particular considerations that are, I guess, different if you're an international business coming into New Zealand as opposed to just a New Zealander starting a business in New Zealand?
Yeah, so there's just a couple of kind of main points that you need to be aware of. So with that company incorporation process, obviously it's really straightforward, it's quick, it's cheap. So the only sort of thing that sits outside that is if you've got shareholders that are a large proportion of your shareholders are based overseas, or you're a wholly owned subsidiary of an overseas company, whether that's an Australian company or not, then the Companies Office does have discretion to ask for more information. So what that looks like is basically you are diving down into the detail of the directors and the shareholders. They might need to be providing certified copies of passports. They might ask for information about your ultimate holding company. So they'll be looking beyond your immediate shareholder and seeing what the ultimate ownership's like. They might look at the shareholders of those companies and get verification requirements there. So it's just something that basically slows the process down quite a lot. And sometimes that will impact, your structuring considerations. So you might say, well, actually, I'm going to set up a separate New Zealand company and I'm going to make sure it's got a higher proportion of New Zealand ownership, or, Australian Australian ownership usually can get around those information requirements. The Companies Office is less interested in them, but I've definitely seen them delve into that ownership in quite a lot of detail in the past, depending on the situation, particularly if there's a complex kind of trust structure sitting up top. So just something worth noting. It's a relatively new discretion, relatively new. It's been around for a few years now, but you see the Companies Office exercising it quite freely. So just something to be aware of. And then the other thing
Sorry, we've had a question that's just come through and worth mentioning in this context, which is, you're required to have a New Zealand resident director when setting up a New Zealand company. In the same way as in Australia, you are required to have an Australian resident director.
Yeah, it's a really common question. So yes, you do as the default position, but Australia sits slightly outside of that. So if either you have a New Zealand resident director or you can have an Australian resident director, provided they're also a director of an Australian company. So when you set up, you just have to provide the ACN of the company in Australia that you're a director of, and that would satisfy that requirement. If you've got neither of those options, then it gets slightly trickier, but there are certain organisations around that will offer, those resident director services, same as in Australia, and they basically act as an independent director for companies with overseas ownership. There are fees that apply to those services, and that basically just depends on, the size and complexity of the business and the risk profile of the industry that they're operating in.
I mean, given obviously on this webinar, we've presumably mainly got Australian business owners who are looking to launch in New Zealand. All those Australian businesses should have a company set up in Australia, I would hope, yep. and they'll have a director. So it's that person that you can make the director of your New Zealand entity, and that's really kind of, it's a lot simpler for Australian businesses launching in New Zealand than the reverse, New Zealand businesses launching in Australia from that perspective, from the resident director perspective.
Yeah.
All right, good. Let's move on to we've got another question here, which is what if you're a New Zealand citizen but an Australian resident? I think
you'd still need to comply with the Australian director requirement there.
Okay.
So it's all about residency.
Yeah, it's residency. So hence the term resident director.
Correct.
Okay, good. Let's move on to your sort of obligations when running when director, owner of a limited liability company in New Zealand. Again, look, to cut it all short, it's pretty similar to Australia. But again, I think a lot of people on this webinar probably aren't necessarily aware of their obligations as directors of Australian companies. So why don't we sort of get into the basic details of what you need to kind of make sure you're on top of?
Yeah, so the first one there is around your company records. So any people online that have got Australian companies, you'll be really familiar with the requirements here. So it's having a share register, directors register, interest register. The key one there, same in Australia, and we see a lot of clients tripping up on this, is that share register is key. So it's evidence that you actually own your shares. So what we find is people will update the Companies Office website, which they are required to do if there's any change there. But if you have, say, a transfer of shares, you've updated the Companies Office website, but you haven't updated your share register, then your transferor or your seller is still the legal owner of those shares. So you are actually required to separately create and maintain that register. And that's often forgotten, particularly in New Zealand, because that Companies Office incorporation process is so straightforward. You actually never get prompted to set up that register. So we see a lot of companies that don't have that in place. And particularly in a kind of a business sales situation, if you're acting for the vendor, often what's happening is that the vendor is scrambling around trying to create that in retrospect. So it's just something worth setting up right from the outset, and then keeping that maintained going forward. So that's that'll all be familiar stuff to the Australian companies. The next one, obviously, I touched on is updating the Companies Office register. So that's basically any change to that publicly available information. So share issues, transfers, director appointments, resignations, things like that, they all need to be updated as you go. And the general requirement, the usual time frame under the Companies Act for those updates is 10 business days. So it's just something that, again, you kind of need to stay on top of and make sure that you do that quickly. Then we've got their annual returns. So it's got nothing to do with, tax or financials, but that's just simply checking that all that publicly available information is up to date. Really simple process, basically download your extract and check it's all correct. The issue there is if you fail to do that, the registrar actually has an ability to strike you off. So it's just key to have someone basically nominated to keep an eye on that and do that annually.
And is there an annual renewal fee like there is in Australia for an Australian company, or?
Yeah, there is. So your general updates of information as you go throughout the year, there's no cost attached to those, but your annual return, there is a cost attached. And I'm not sure what it is off the top of my head, but it's around the $100 or $200 mark, New Zealand dollars.
Yeah, same as Australia.
So, so nothing major. And then the other one that I've just put there, which is worth touching on, but probably not relevant to a lot of people in the kind of SME high growth startup place, is the financial reporting. So that's when you have to register your financial statements on the Companies Office website, but that only applies to some large companies and some overseas companies. And there are different nuances there, but in general, those thresholds are around the more than $20 million of assets or more than 10 mil of revenue, and that has to be over your previous 2 accounting periods. So it's quite a high threshold. But for some of the Australian companies that are looking at just, and we can touch on this later, but just looking at registering a branch in New Zealand and not actually setting up a separate entity, that can be a really important consideration in terms of how you structure that launch into New Zealand, because if you are touching on those thresholds, then you are going to have to register those financial statements and they're going to be publicly available. Whereas if you set up a New Zealand subsidiary, then the financial thresholds only apply to your New Zealand subsidiary and their subsidiaries. So you can get away from, potentially releasing that financial information to your competitors inadvertently by fact of, having to do the whole group. So it's just another thing to kind of keep in mind for those bigger Australian companies wanting to launch.
Yeah, okay. And well, that's kind of a good segue into kind of the next little section, which is you actually need to incorporate a company to do business in New Zealand, or are the alternative options that the viewers should be considering?
Yeah, and we get this question a lot, particularly with those Australian clients trying to launch into New Zealand. I guess the high level short answer is no, you don't have to do it, but to a certain point. So you have to be looking at your business and you have to look at that expansion into New Zealand and figure out at what stage you're at. So if you're just, say, testing the market, you've got no permanent or physical presence in New Zealand, there's no need. So you might just be testing the product. You don't want to have any sort of expensive capital outlay, then that's a good solution. It's good for online businesses. You can test the demand and then kind of figure out what your plans are, how serious you are about the launch, and go from there. The point in time that you do actually have to register either as an overseas company in New Zealand or set up a new New Zealand subsidiary or company, whether it's a subsidiary or not, is when you are deemed to be doing business in New Zealand. So, I mean, what does that mean? It's a grey area. It kind of depends on, fact and circumstance of that particular company, but the kind of things that you're looking at there are, do we have a physical place of business there? Do we have New Zealand employees? Do we have a bank account? Are we basically negotiating and concluding deals in New Zealand? You're looking for some element of permanence, I guess, and as soon as you're meeting a few of those requirements, then you have tipped into this category of doing business in New Zealand, in which case you do need to register either as an overseas company or as a new New Zealand company.
Okay. All right. So I think that sort of covers. What a question that's come in. This is a good one. I'm getting conflicting information on whether our business needs to set up a New Zealand corporation or whether we can simply register for GST in New Zealand without incorporating and manage the New Zealand business from Australia. Could you advise? Sort of fits in with this sort of topic, I guess.
Yeah, and look, it's a good question. So that's kind of, again, tipping into, if you've registered for GST in New Zealand, are you tipping into that as a grey area? Are you tipping into that category of actually you've gone to the effort of registering in for GST in New Zealand? You're probably concluding your business or transactions in New Zealand, so you've probably erred on that side of doing business here and needing a separate entity. The GST question, I know we had another question about that as well, is, it's an important one to consider. So basically, if you're selling goods to New Zealand customers through, say, a New Zealand entity, if you did decide to set it up, then you're needing to charge GST, so you need to be registered. There is a threshold there, so you only need to register if your turnover is 60,000 over a 12-month period. If it's below that, then there's just optional registration. But if you are an Australian company and you want to sell goods through your Australian entity without any separate New Zealand entity, then there wouldn't be any GST that applies. It'd be classified as an export. So it depends on how you want to structure things going forward. But my sort of key comment there would be, if you're thinking you need a GST number, I would be suggesting look at the broader picture of your business operations in New Zealand and have a think about whether you do meet that sort of doing business in New Zealand test.
Yeah, no, for sure. And then, just in terms of running your operations, very quickly it can be difficult to run overseas operations without a presence, depending on the type of business you're running. If you're running a SaaS business, that's a separate kind of kettle of fish. And the reality is, with the SaaS business, you could be selling in 130 different countries. You're not going to set up operations in 130 different businesses, 130 different jurisdictions. But if you're running a business that requires hiring people, or you want to have contracts specific to New Zealand with New Zealand customers, then it starts to get actually easier just to have a separate company. And so that's, it's not so much a legal question, but more a ease of doing business question. All right, let's move on to the next segment, which so a couple of big points. The first is, anyone who's considering launching in New Zealand, I highly encourage you to download our New Zealand Startup Manual, which is a legal handbook for founders. Gives you a bit of insight into running a startup in New Zealand. It's very much focused on the kind of tech startup side of things. But there's obviously things that are relevant to any type of business in that. We've also got some handouts, an online business guide to doing business in New Zealand, and a guide to New Zealand trademarking, both worth a read as well. Look, I think that the key point for Australian businesses is New Zealand's a pretty similar jurisdiction, but there's slight things that are different. They do things a little bit differently. GST's a different percentage. There's just a whole bunch of things that you kind of need to get your head around. But when you do, it's certainly a very easy jurisdiction to do business in if you're an Australian business. So I think we can probably move on to the questions now. We'll go through the questions, and then what we'll do at the end is we'll quickly talk a bit about how we can help your business expand to New Zealand and how LegalVision operates. So I'll just quickly have a look through. Here's a good one. What do you think of a SaaS business operating from New Zealand and selling globally, including Australia, but having directors in Australia? It's sort of the reverse, I think, really. This is a New Zealand business that is kind of selling globally, and their directors are based in Australia, not in New Zealand.
Yeah, it's an interesting question. I think, again, not necessarily a legal question, because you can absolutely do that. There's no problems with it. the reason it's quite popular and you see a lot of companies doing it is that the regulatory environment in New Zealand is so, I guess, robust that people have a lot of trust in New Zealand companies. So they like dealing with New Zealand companies. They know that they're operating in an environment that is regulated. There is a lot of oversight. So it's sort of, I am operating, or I am dealing with, you know, a legitimate business here. And we're also a country where the entrepreneurial environment is growing so rapidly. There's a lot of internationals, particularly in the COVID environment, that have decided to relocate to New Zealand. And so it's actually quite common that we've got global companies that are based in a small town in the South Island that are actually reaching out into multiple jurisdictions. And then obviously that question around the director, no problems. You can basically be completely set up in Australia with your Australian resident director and create your New Zealand company without necessarily any people on the ground in New Zealand.
The question you'd have to ask yourself is why you want to do that. You know, I mean, obviously there's reasons that you've given there, but you'd have to say, you know, the Australian regulatory environment is kind of pretty similar. So there'd be I can't think of any real reason, if you're based in Australia, why you wouldn't just run your SaaS business through an Australian business, Australian company. But look, this is a thing in the world we live in. There's all sorts of weird and wonderful reasons for doing various things. So everyone's circumstances, I guess, are individual to that person. So there could be a reason to do it. Just can't.
Like a founder that wants to be based in Wanaka and go skiing every day. That's exactly why you do it.
Well, there you go. I guess you'd move there, right? Okay, so what are the key considerations while structuring for New Zealand investments? And I guess this is someone looking to raise capital in New Zealand. What are the sort of things that you need to consider from that perspective that are different to Australia, I guess?
Yeah, so in terms of difference from Australia, I would say not very much. So kind of the key things that your investors are going to be looking for is, how have you structured your business? Do you have those key assets that should be sitting in a holding company, separated out from your operating company? They'll be looking at that. They'll be looking at, do you have vesting provisions in place for your founders? We want to make sure that they are staying in the business because that's key. Have you set aside an ESOP allocation to make sure that your key employees are incentivized? They'll be looking at your IP. So often a lot of IP gets created by the founders before they've set up their sort of more formal structure. And so they'll be looking to get assignments of IP into the company, so that, you know, they're investing in a company that actually owns what they think it owns. These are all things to be, you know, it's great to put them in place up front if you can. And we love it when clients come to us and say, we want to set up properly from the outset, and we can do that all for you. In reality, often you're just negotiating it at the time of that first price round. So usually it's at that point that you're setting up all of those IP assignments. You're negotiating a new shareholders agreement that sets out that founder vesting, all of that kind of stuff. So that first major fundraising round can be, I guess it can take a little bit longer than you might expect, just because you've got a lot of kind of conditions to set that up properly from the outset. But it means that once you've done that once, then you're sort of good to go for later funding rounds. It's a lot more of a smooth process. The only sort of difference, I guess, in a New Zealand context is around obviously the disclosure obligations, which is the same in Australia. But so the Financial Markets Conduct Act basically governs any share issues. So again, you know, disclosure obligations apply so that you're protecting your members of the public, and they can be really extensive in terms of time and cost. So you're looking at what exceptions might apply to you in New Zealand, and they're the same sorts of flavours as what would apply in Australia. So, you know, is it a small offer? Is it being done under the ESOP exemption? Are you just offering to sophisticated investors and the like? The only thing that will look different is that there are certain requirements in terms of warning statements that you have on your subscription agreement. So these are prescribed by regulations, so you can't negotiate them. They'll be sitting front and centre on top of your subscription agreement. They'll also be embedded in your plan rules for your ESOP as well. So there are things that's kind of the little nuances that you're like, actually, even though you might be using a market standard document, you need to be really careful that you are including those requirements to make sure that you can rely on those exemptions. And the FMA is really active in that space in terms of making sure that you are complying.
Okay, no, that's good. I mean, look, you know, we've obviously been doing a lot of work for New Zealand startups in the capital raising space since we launched over in New Zealand, and George, you've been leading that. And my kind of overall view of it, it's pretty similar to Australia in terms of the capital raising environment, in the early stage environment at least, but with those little nuances. And so, no, look, having the ability to help startups raise capital either in Australia or New Zealand is obviously one of the things that we've tried to build here at LegalVision, and it's going very well. Look, I think we're done with the questions now. Let's move on to the next slide. Just wanted to quickly touch on how we can help Australian businesses that are looking to expand to New Zealand. So LegalVision is primarily a membership-based organisation. So most of our clients are members of our LVConnect Pro product. And this product is basically designed to give our members access to all of the business as usual legal help that they need. So we'll basically do any document reviewing and drafting that's unlimited advice consultation with our lawyers, company corporations and setting up in New Zealand if that's what you need, unlimited Australia and New Zealand trademark applications, and unlimited employment law help. So the model that we kind of work with, and many of you on this webinar will be members, is really focused on building a deep relationship with our clients, and that's why we have this membership product. Now, what we've done with the New Zealand launch is anyone who is a LegalVision Australia LVConnect Pro member gets access to unlimited support in New Zealand, and anyone who's a New Zealand LVConnect Pro member gets unlimited support in Australia. So if you you feel like you need help in either of those two jurisdictions, we would love to talk to you. What we're doing is doing a free strategy session. If it's a New Zealand strategy session, then it'll be with George, where she can kind of talk to you about expanding and talk to you about your particular circumstances and how we can help you in your particular circumstances. Obviously, this webinar is designed to give an overview, but everyone's circumstances are different. So if you're an Australian business looking to expand to New Zealand, get in touch. We've got the details on that slide, and we'll organise a time for you to talk to Georgina, so she can obviously give you some help, but also we can tell you how we can help you through the Pro membership. And if you're an Australian business or a New Zealand business looking to expand to Australia, we can do the same thing. So look, we're really thankful for you to take time to attend. Hopefully you've learned something about expanding to New Zealand. And look, please book in for a strategy session if you're interested in that Pro membership. In the meantime, any particular one-off questions, feel free to just send us a quick email, and we'll try and answer them over email. Have a great day. Thanks, George, for joining, and we'll do another one of these very soon, I'm sure. Thank you again.
Thanks, Lachlan. Bye.